I was standing on my front porch watching the mailman slip and nearly break his neck on my icy steps when I decided enough was enough. The temperature in Boulder, Colorado had dropped to 15 degrees overnight, and the morning sun did nothing to melt the treacherous glaze coating every outdoor surface. My mother, who lived with me and used a wheelchair after her stroke 3 years ago, hadn't been able to leave the house safely in weeks. That afternoon, I called a contractor, Xavier Thornton, that's me, and I'd been living in the Sunset Ridge Estates for 5 years. The neighborhood was beautiful, nestled against the foothills with views of the Flatirons that made every morning coffee feel like a postcard. But beauty came with a price, and that price was dealing with an HOA that seemed to believe their primary purpose was making residents miserable. The contractor, Mike, came out the next day. He was a stocky guy in his 50s who'd been installing heated step systems for 20 years. He walked around my front entrance, took measurements, and nodded approvingly at my concrete steps. "This is perfect for a radiant heating system," he said, tapping his clipboard. "We'll run electric heating cables under new pavers. You'll have ice-free steps year-round. With your mom's wheelchair, this is exactly what you need. How long will installation take? 3 days, maybe 4. We need decent weather to set everything properly. Looking at the forecast, we could start Monday." I signed the contract that afternoon. Mike assured me the system was energy efficient, safe, and virtually invisible once installed. The heated steps would look identical to my existing ones, just slightly taller to accommodate the heating elements and new pavers. He'd done dozens of installations in Boulder County alone. Monday morning arrived with the roar of Mike's truck and the cheerful chaos of construction. My mother watched from the living room window, excited about the prospect of leaving the house again without me having to carry her down slippery steps. The workers jackhammered out the old concrete, laid the electrical groundwork, and began building up the new heated system. By Wednesday afternoon, the steps looked incredible. The pavers matched my house perfectly, and Mike demonstrated the system with a garden hose. Water hit the steps and evaporated within seconds, steam rising into the cold air. My mother clapped her hands together, already planning trips to her physical therapy appointments and lunch with her friends. Thursday morning, I was testing the temperature settings when a silver Honda Civic pulled into my driveway. Out stepped a woman in her late 40s with a blonde bob that looked like it required daily maintenance and a purple pantsuit that screamed, "I need to speak to your manager." She clutched a leather portfolio against her chest like a shield. "Are you Xavier Thornton?" She called out, her voice carrying that particular tone of faux politeness that immediately put me on guard. "That's me. Can I help you?" She marched up to my new steps, her heels clicking against the pavers. "I'm Patricia Winters, president of the Sunset Ridge Estates HOA board. We've received several complaints about your unauthorized construction project." I felt my jaw tighten. "Complaints?" I replaced my front steps. "They're the same size and style as before, just safer." Patricia's eyes narrowed. "You didn't submit an architectural review request form for approval." According to our bylaws, Section 12, Paragraph 4, any exterior modifications require board approval 30 days prior to construction. "They're steps, Patricia. I'm not building a second story or painting my house neon green. The rules exist for everyone, Mr. Thornton. I can see heating elements here." She pointed at the nearly invisible control box mounted near my front door. "These steps are heated, aren't they?" "Yes, for safety. My mother uses a wheelchair and icy steps are dangerous." Patricia pulled a printed document from her portfolio with the flourish of a magician, producing a rabbit. "This is a cease and desist order from the HOA board. You have 14 days to remove the heated steps and restore your entrance to its original condition, or face daily fines of $100. My mother had wheeled herself to the front door and was watching through the glass. I could see the disappointment already forming on her face. You can't be serious. These steps prevent accidents and allow my disabled mother to access her own home safely. The HOA has very specific guidelines about modifications, Mr. Thornton. We've denied heated driveway requests in the past, and this falls under the same category. It creates an unfair aesthetic variance in the neighborhood. Aesthetic variance. They look exactly like regular steps. Patricia's smile was thin and cold. Nevertheless, our decision is final. 14 days, Mr. Thornton. Good day. She walked back to her Honda, leaving the cease and desist notice on my porch railing. I watched her drive away, my hands clenched into fists. Inside, my mother had tears running down her cheeks. "I'm sorry, honey," she said when I came in. "I don't want you getting in trouble because of me." "Mom, this isn't your fault. Patricia Winters is on a power trip, and I'm not removing those steps." That evening, I read through the HOA bylaws cover to cover. They were 78 pages of dense legalese that seemed designed to regulate everything from fence heights to acceptable mailbox styles. Section 12 did indeed require architectural review for exterior modifications, but it included exceptions for safety improvements and repairs. The language was vague enough to interpret multiple ways. I called my friend Derek, who was a real estate attorney in Denver. We'd gone to college together at CU Boulder and stayed close over the years. He listened to my situation and whistled low. "HOAs can be nightmares, Xavier. But you might have a case here. The Americans with Disabilities Act requires reasonable accommodations for disabled residents. Your mother's wheelchair use could qualify these heated steps as a necessary accommodation. Can they really fine me $100 a day? They can try. But if you can prove the steps are an ADA-required accommodation, they're on shaky legal ground. Let me do some research and call you back." Derek phoned me back 2 hours later, and I could hear the excitement in his voice. "Xavier, I think we've got them. The ADA specifically addresses ice-free accessibility. The Department of Justice has issued guidance stating that property owners must provide safe, accessible routes free from snow and ice. For a wheelchair user, heated steps could absolutely be considered a reasonable accommodation." So what do I do? First, get a letter from your mother's doctor stating her mobility needs. Then we'll draft a response to the HOA citing the ADA and Fair Housing Act. If they push back, we'll file a complaint with HUD and potentially pursue legal action. Will that cost a fortune? Derek laughed. "For you, I'll do it pro bono. HOAs that violate disability rights are my personal crusade. I've been waiting for a case like this." The next morning, I took my mother to her doctor, Dr. Sarah Chen, who'd been treating her since the stroke. Dr. Chen was appalled when she heard about the HOA's demand. "That's absolutely ridiculous," she said, typing on her computer. "Your mother requires wheelchair accessibility, and icy conditions pose a serious safety hazard. I'm writing a detailed letter explaining her medical needs and the necessity of ice-free access to your home." She printed the letter on the spot, her official letterhead lending weight to every word. The document outlined my mother's limited mobility, her dependence on wheelchair access, and the medical risks posed by icy conditions, including potential falls, hypothermia exposure, and the inability to evacuate in emergencies. Derek received the letter and worked his magic. 3 days later, I got a thick envelope in the mail containing his response to the HOA. It was beautiful, 8 pages of legal citations, HOA requirements and Fair Housing Act provisions. The key paragraph made me smile. The heated steps installed by Mr. Thornton constitute a reasonable accommodation under the Americans with Disabilities Act and the Fair Housing Act. Federal law requires that disabled residents have ice-free accessible routes to their homes. The HOA specifically mandates that walking surfaces be kept free of snow and ice. Heated steps are a permanent, effective solution that ensures continuous accessibility for Mrs. Alina Thornton, a wheelchair user. Any attempt to force removal of these steps or impose fines violates federal disability rights law and exposes the HOA to significant legal liability. Derek included citations to specific court cases where HOAs had lost similar battles, along with a reminder that the Fair Housing Act allowed disabled residents to make necessary modifications at their own expense. He concluded with a polite but firm suggestion that the HOA immediately rescind their cease and desist order. I mailed Derek's response via certified mail to ensure Patricia couldn't claim she never received it. Then I waited. The 14-day deadline came and went without any response from the HOA. I assumed they'd backed down and moved on with my life. My mother was thrilled, using her new accessible steps daily to visit friends and attend her appointments. 2 weeks later, I received another letter from Patricia. This one informed me that the HOA board had met and voted to uphold their decision. Furthermore, they were now imposing the daily $100 fine starting immediately. A separate invoice demanded $1,400 for the days since the original deadline. I called Derek, furious. They're completely ignoring the HOA argument. Patricia sent me a fine notice. Perfect, Derek said, and I could hear him grinning. They just gave us everything we need for a lawsuit. They've been informed of the federal law requirements and chose to violate them anyway. That's willful discrimination. What's our next move? We file a complaint with the Department of Housing and Urban Development and prepare a federal lawsuit. I'll also send Patricia one more letter making it crystal clear what legal territory they're walking into. If they don't back down after that, we go nuclear. Derek's second letter arrived at the HOA office 3 days later. This one was shorter but far more pointed. He outlined the potential damages the HOA faced, including compensatory damages, punitive damages, and attorney fees. He cited cases where HOAs had been forced to pay hundreds of thousands of dollars for disability discrimination. He gave them 7 days to rescind all fines and cease any further action regarding the heated steps. Day 8 arrived with a knock on my door. This time it wasn't Patricia but 2 other board members, Gary Henderson and Melissa Cook. Gary was a retired accountant who seemed perpetually nervous, while Melissa taught high school English and had always struck me as reasonable. "Xavier, can we talk?" Melissa asked, her expression apologetic. I let them into my living room where my mother was reading a book. She glanced up, recognized them from neighborhood events, and wheeled herself into the kitchen to give us privacy. Gary spoke first, wringing his hands. "We wanted you to know that Melissa and I voted against the fines." It was Patricia who pushed this through. She's convinced that if we let one person modify their property without approval, the whole system falls apart. "The whole system," I said. "We're talking about heated steps that prevent my disabled mother from being trapped in the house all winter." Melissa nodded. "We understand that, Xavier. We really do. But Patricia has controlled this board for 6 years, and she doesn't take challenges well. She's threatening to quit if we override her decision, and frankly, nobody else wants to be HOA president." "So you're letting her violate federal disability law because she'll quit?" Gary shifted uncomfortably. "When you put it that way, it sounds terrible. We were hoping maybe we could reach a compromise. What if you submitted a retroactive approval request and we fast-tracked the approval? I shook my head. No compromise. The law is clear. My mother has a right to accessible housing, and these steps are a necessary accommodation. I'm not playing Patricia's games or pretending she has the authority to approve or deny something required by federal law. Melissa sighed. I was afraid you'd say that. For what it's worth, I'm sorry. I'll be voting against Patricia at every turn on this issue. After they left, my mother wheeled back into the room. Those two seemed nice enough. Why don't you take their compromise? Because it's not about being nice, Mom. It's about the law. If I back down, Patricia will think she can bully anyone who doesn't follow her arbitrary rules. What happens to the next person who needs a disability accommodation? Or someone who paints their door the wrong shade of beige? These HOAs need to learn they're not above federal law. My mother smiled and squeezed my hand. You always were stubborn. I'm glad you inherited that from me. The next 2 weeks were quiet, and I started to hope Patricia had finally gotten the message. Then I came home from work to find a sheriff's deputy waiting in my driveway. My heart dropped into my stomach as I parked. Mr. Thornton, the deputy asked, checking his paperwork, I have a small claims summons for you. The Sunset Ridge Estates HOA is suing you for $5,000 in unpaid fines and demanding removal of unauthorized construction. I took the papers, my hands shaking with anger. They were actually taking me to court. Thanks, officer. Good luck, he said, and something in his tone suggested he'd dealt with HOA disputes before and didn't enjoy them. I called Derek immediately. He was in a meeting but called back within 20 minutes. They actually filed in small claims. That's bold and incredibly stupid on their part. Why stupid? Because small claims court has a $10,000 limit, but our federal case can go much higher. Plus, we were going to file in federal court anyway. Now they've opened themselves up to counterclaims and given us a perfect venue to expose their ADA violations publicly. Xavier, I hate to sound excited about your stress, but this is perfect for our case. What do I do? Nothing yet. We'll file our answer to their small claims suit, then immediately file our federal complaint for disability discrimination. We'll also request that the small claims case be stayed pending the outcome of the federal case, since federal law supersedes HOA bylaws. This is going to get interesting. Interesting was one word for it. The next month was a blur of legal paperwork. Derek filed a comprehensive federal complaint against the Sunset Ridge Estates HOA, Patricia Winters personally, and the management company that administered the HOA. The complaint alleged violations of the Americans with Disabilities Act, the Fair Housing Act, and Colorado state disability rights laws. We sought injunctive relief preventing the HOA from interfering with the heated steps, compensatory damages for emotional distress, punitive damages, and attorney fees. The complaint was a masterpiece. Derek outlined every interaction, included Dr. Chen's letter, cited the specific ADA provisions requiring ice-free accessibility, and painted a vivid picture of an HOA board that put aesthetics over a disabled woman's safety and mobility. Patricia's response came through her attorney, a guy named Robert Mills who specialized in HOA defense. His answer to the federal complaint was predictably defensive, arguing that the HOA had a right to enforce its bylaws uniformly, and that heated steps weren't explicitly mentioned in ADA accessibility guidelines. Derek practically laughed when he read it. They're arguing that because heated steps aren't specifically mentioned, they're not required. That's like saying wheelchair ramps aren't required because the law just says accessible entrance without specifying the method. Any competent disability rights attorney would demolish that argument. We had our first hearing in federal court on a cold February morning. Judge Sandra Martinez presided, a no-nonsense former civil rights attorney who'd been on the bench for 12 years. The hearing was just a preliminary matter to address the HOA's motion to dismiss, but it gave me my first look at Patricia in a legal setting. She sat behind Robert Mills, her expression confident and stern. She kept glancing at me with obvious disdain, as if I were a troublemaking child who'd gotten sent to the principal's office. Her attitude shifted dramatically when Judge Martinez started asking questions. "Mr. Mills," the judge said, peering over her reading glasses, "your argument is that the HOA's architectural review process supersedes federal disability law." "Not supersedes, Your Honor, but runs parallel to. Mr. Thornton could have requested approval through the proper channels. For a federally mandated accommodation, Mr. Mills, are you truly arguing that an HOA can veto ADER requirements?" Robert Mills, to his credit, seemed to realize he was on thin ice. "We're arguing that the process exists for everyone, disabled or not." Judge Martinez flipped through the papers before her. "According to this complaint, Mrs. Xavier Thornton is a wheelchair user who requires ice-free access to her home. The heated steps provide that access during winter conditions that are both common and dangerous in Colorado. Mr. Mills, point me to any legal authority suggesting an HOA can prohibit a reasonable disability accommodation." "Your Honor, the reasonableness is in question. There are alternative methods for ice removal, such as manual shoveling, salt application, temporary ramps." Derek stood to respond. "Your Honor, if I may, the ADA specifically requires permanent, reliable, accessible routes. Manual shoveling depends on someone being available at all times, which is neither permanent nor reliable. Salt can damage concrete and is ineffective in extreme cold. Temporary ramps for wheelchair use on icy steps are inherently dangerous. Heated steps provide a permanent, maintenance-free solution that ensures continuous accessibility." Judge Martinez nodded slowly. "Mr. Mills, I'm denying your motion to dismiss. This case raises significant questions about the intersection of HOA authority and federal disability rights. We'll proceed to discovery. I'm also granting a preliminary injunction preventing the HOA from assessing any fines or taking any action against Mr. Thornton regarding the heated steps pending trial." Patricia's confident expression crumbled. She leaned forward and whispered urgently to Robert Mills, who held up a hand to quiet her. The judge noticed the exchange. "Miss Winters, I assume you're the HOA president named in this complaint." Patricia stood awkwardly, clearly unused to courtroom procedure. "Yes, Your Honor." "Let me be very clear. Federal disability law is not optional. HOA, despite their broad authority over aesthetic matters, cannot discriminate against disabled residents. If these heated steps are indeed a necessary accommodation, and that appears likely based on the preliminary evidence, your HOA has no authority to demand their removal. Do you understand?" "Yes, Your Honor," Patricia said quietly, sitting back down. We left the courthouse with Derek practically bouncing with excitement. "Did you see her face? Judge Martinez basically told her she has no case. I bet they'll try to settle now." "Would we accept a settlement?" "Depends on the terms. We want all fines dropped, permanent written acknowledgement of your mother's right to the heated steps, and our attorney fees paid. Anything less, we go to trial." 2 days later, Robert Mills called Derek to discuss settlement. The conversation didn't go well. The HOA offered to drop the fines and stop pursuing removal of the steps, but they refused to pay attorney fees, and wanted a clause stating that the settlement didn't constitute admission of wrongdoing. Derek countered with our terms. The HOA would pay $20,000 to cover attorney fees and my mother's emotional distress, provide a written acknowledgement that the heated steps were a necessary HOA accommodation, and amend their bylaws to include explicit language about disability accommodations, superseding architectural review requirements. Mills said he'd take it to the board. 3 days later, he called back. Patricia had rejected the settlement and convinced the other board members to proceed to trial. She was apparently convinced that a jury would side with property rights over disability accommodations. "She's delusional," Derek told me over drinks at a Boulder brewpub. "No jury is going to side against a wheelchair-bound stroke victim who just wants safe access to her home. But if Patricia wants to take this to trial, we'll absolutely destroy her case in front of 12 citizens." Discovery was brutal for the HOA. Derek subpoenaed all board meeting minutes, emails, and correspondence related to my heated steps. What emerged was a pattern of Patricia steamrolling the other board members and ignoring multiple warnings that she was violating federal law. One email chain was particularly damaging. After receiving Derek's first letter outlining the HOA requirements, Melissa Cook had written to Patricia, "I'm very concerned we're violating disability law. We should consult with an attorney who specializes in HOA compliance before proceeding with fines." Patricia's response, "The HOA doesn't override our covenants. If we let Xavier do whatever he wants, everyone will start ignoring the rules. We need to stand firm." Gary Henderson had followed up. "Patricia, I looked up some of those court cases Xavier's attorney mentioned. HOAs lost badly and had to pay huge settlements. Maybe we should back down on this one." Patricia again, "Those cases are different. Xavier's mother can still access the house, just not as conveniently. The HOA only requires basic access, not heated luxury steps." Derek photocopied those emails in large print for the jury trial exhibits. "She's not just wrong about the law," he explained. "She's been repeatedly told she's wrong and chosen to continue anyway. That shows willful discrimination, which opens the door to punitive damages." We also deposed Patricia, which was uncomfortable and enlightening. Derek questioned her for 4 hours, and she grew increasingly defensive and hostile. When asked why she'd rejected the advice to consult an HOA attorney, she claimed it would have been too expensive. When asked if she'd even read the HOA provisions Derek had cited, she admitted she hadn't. "You didn't read the federal law that multiple people told you was relevant to this case?" Derek asked, his tone professionally neutral but his eyes gleaming. "I read the HOA bylaws," Patricia said stiffly. "That's my responsibility as president." "And you believe HOA bylaws supersede federal law?" "I believe people need to follow the rules they agreed to when they bought their homes." Derek showed her Dr. Chen's letter. "You received this medical documentation that Mrs. Thornton requires wheelchair accessibility, correct?" "Yes." "And you still demanded removal of the heated steps. The steps aren't the only way to handle ice, but they're the most effective permanent solution for ensuring continuous accessibility, correct?" Patricia's lawyer objected, but the damage was done. She clearly hadn't thought through the implications of her position. We also deposed the HOA's expert witness, an architect named Richard Crane who'd worked with HOAs for 30 years. Derek's cross-examination was surgical. "Mr. Crane, are you familiar with HOA Title Roman III accessibility requirements?" "Generally, yes." "Are you certified in HOA compliance?" "No, but I understand the basic principles." "The basic principles. Can you cite the specific provisions regarding ice-free accessible routes?" Richard hesitated. "Not off the top of my head, no." So you're not actually an expert in ADA compliance, just HOA architectural standards. That's correct. And HOA architectural standards must comply with federal disability law, correct? I suppose so, yes. Derek leaned forward. Mr. Crane, in your professional opinion, are heated steps an effective method of ensuring ice-free accessibility for a wheelchair user during Colorado winters? Richard glanced at Patricia, who was glaring at him from across the conference room. He cleared his throat. They would be effective, yes, but there are other methods. Methods that require daily manual intervention or depend on weather conditions. Yes. Whereas heated steps provide automatic, continuous protection. Yes. No further questions. As discovery progressed, something unexpected happened. Other Sunset Ridge Estates residents started reaching out to me. Apparently, Patricia's authoritarian approach to the HOA had created plenty of enemies over the years. A man named Tom Patterson stopped me at the grocery store. Xavier, I heard about your lawsuit against the HOA. I'm rooting for you. Patricia fined me $2,000 last year because my fence was 6 inches too tall. 6 inches. I had to rebuild the entire thing. A woman named Jennifer Mills, no relation to the HOA's attorney, sent me an email. Patricia rejected my request to install solar panels even though Colorado law protects homeowners' rights to solar energy. She claimed they were visually unappealing. I eventually gave up fighting her. I hope you win. The stories kept coming. Patricia had created a culture of fear in the neighborhood, where residents were afraid to make any changes to their properties without extensive approval processes that she controlled completely. People painted their houses boring colors because Patricia had rejected anything interesting. Gardens were limited to approved plant lists. Holiday decorations faced strict time limits and style requirements. Derek asked if any of these people would be willing to testify about Patricia's pattern of behavior. 6 residents immediately volunteered. We couldn't use most of their stories directly, since our case was specifically about disability discrimination. But their testimony would establish Patricia's authoritarian mindset and unwillingness to consider residents' needs. The trial was set for late April, nearly 6 months after Patricia had first appeared in my driveway. As the date approached, my mother grew nervous. "What if we lose?" she asked one evening. "What if they make you remove the steps?" "We won't lose, Mom. The law is on our side, and we have overwhelming evidence. Even if something went wrong at trial, which it won't, we'd appeal. Those steps are staying. I still feel guilty that you're spending so much time and energy on this." I knelt beside her wheelchair. "Mom, this stopped being just about the steps a long time ago. Patricia and her HOA are bullies who have gotten away with trampling people's rights for years. Somebody needs to stand up to them, and it might as well be us." The weekend before trial, Derek came to my house for final preparation. He brought his trial binders, meticulously organized with tabs for every document, witness, and legal citation. We sat at my dining room table running through his opening statement. "Ladies and gentlemen of the jury," Derek practiced, "this case is about a simple question. Does a disabled woman have the right to safely access her own home? The defense will try to make this complicated. They'll talk about property rights and architectural review processes and community standards. But at its core, this case is about Xavier Thornton's right to leave her house without risking her life on icy steps." My mother listened from the living room, dabbing at her eyes with a tissue. "He's good," she called out. "Very good." Derek grinned. "Wait until you hear the closing. I'm saving my best material for that." Trial began on a Monday morning in late April. The federal courthouse in Denver was an imposing granite building with high ceilings and marble floors. We went through security, rode the elevator to Judge Martinez's courtroom, and took our seats at the plaintiff's table. Patricia sat at the defense table with Robert Mills and a young associate who looked fresh out of law school. She wore a navy suit and pearl earrings, her expression carefully neutral. When my mother wheeled into the courtroom, however, Patricia's mask slipped for just a moment. She looked uncomfortable, perhaps realizing how bad the optics were of fighting against a disabled elderly woman. Jury selection took most of the morning. Derek was brilliant at it, asking questions that subtly revealed each potential juror's attitude toward disability rights and HOA authority. He struck anyone who seemed overly sympathetic to property rights arguments and kept people who had disabled family members or negative HOA experiences. We ended up with 8 jurors, 6 women and 2 men, ranging in age from late 20s to mid-60s. One woman used a cane and had visible difficulty climbing into the jury box. Derek caught my eye and nodded slightly. That juror would understand accessibility issues personally. Judge Martinez explained the trial procedures, then invited Derek to give his opening statement. He stood, buttoned his suit jacket, and approached the jury box with quiet confidence. "Ladies and gentlemen, thank you for your service. This case is about ICE and wheelchairs and whether an HOA can prevent a disabled woman from safely accessing her home. Mrs. Xavier Thornton had a stroke 3 years ago. She uses a wheelchair. She lives with her son, Xavier, in the Sunset Ridge Estates neighborhood of Boulder, Colorado. And during the winter months, ice forms on steps and sidewalks, creating dangerous conditions for everyone but especially for wheelchair users." He gestured to where my mother sat in the gallery. "Mrs. Thornton couldn't leave her house safely last winter. The ice on the front steps meant she was trapped inside unless her son carried her down, which was dangerous for both of them. So Xavier did what any good son would do. He installed heated steps, which automatically prevent ice formation. Problem solved, right? Wrong." Derek held up the cease and desist letter Patricia had delivered. Patricia Winters, president of the Sunset Ridge Estates HOA, demanded that Xavier remove these heated steps. Why? Because he hadn't asked permission first. Never mind that federal law requires ice-free accessible routes for disabled residents. Never mind that the heated steps looked virtually identical to the original steps. Never mind that Mrs. Thornton's doctor had certified the medical necessity of this modification. Patricia wanted those steps gone, and she was willing to fine Xavier $100 a day to make it happen. He walked the jury through the timeline, showing them each letter, each legal warning that Patricia had ignored, each piece of medical documentation she dismissed. His voice was calm but powerful, painting a picture of an HOA president so focused on her own authority that she'd willfully violated federal disability law. The defense will tell you that HOAs need rules and that everyone must follow the same process. They're right about that. But here's what they won't tell you. Federal disability law supersedes HOA bylaws. The Americans with Disabilities Act and the Fair Housing Act specifically protect disabled residents' right to make necessary modifications. Patricia Winters knew this. She was told repeatedly, and she didn't care. Derek returned to our table and placed his hand on my shoulder. "We're going to prove that Xavier Thornton did everything right. He provided a safe, accessible home for his disabled mother as federal law requires. Patricia Winters did everything wrong. She violated the law, ignored medical evidence, and tried to force the removal of a necessary accommodation. At the end of this trial, we'll ask you to hold the HOA accountable and ensure that Mrs. Thornton can safely access her home without fear or interference." Robert Mills gave the defense's opening statement next. He was smooth and professional, framing the case as a matter of community standards and uniform rule enforcement. "This case isn't about preventing a disabled woman from accessing her home," he began. "It's about whether an HOA can maintain standards when residents make unauthorized changes to their property." Xavier Thornton didn't follow the rules. He didn't submit an architectural review request. He didn't give the board a chance to consider his modification. He just did what he wanted and expected everyone else to accept it. Mills argued that heated steps weren't explicitly required by the HOA, and that alternative ice removal methods existed. He claimed Patricia had acted reasonably in enforcing the bylaws, and that the HOA would have approved the modification if Xavier had just gone through the proper channels. The defense will show that Sunset Ridge Estates has approved other disability accommodations in the past. This isn't about discrimination. It's about process and ensuring all residents follow the same rules. We'll ask you to find in favor of the HOA and recognize their right to enforce the bylaws that all residents, including Mr. Thornton, agreed to when they purchased their homes. Derek leaned over and whispered to me, "He's lying about approving other accommodations. We searched the records. They've never approved any disability modification without a fight." The first witness was my mother. Derek wheeled her to the witness stand and the bailiff swore her in. She looked small and fragile in the formal courtroom setting, but her voice was steady when Derek began his questions. "Mrs. Thornton, can you tell the jury about your medical condition?" "I had a stroke 3 years ago. It paralyzed my left side. I use a wheelchair now and probably will for the rest of my life." "Before your son installed the heated steps, were you able to safely leave the house during winter?" My mother shook her head. "No, the ice on the steps was too dangerous. Xavier would have to carry me down, which terrified me. I'm not light and one slip would hurt both of us, so mostly I just stayed inside from November through March." "How did that affect you?" Tears welled in her eyes. "I felt like a prisoner. I missed my physical therapy appointments. I couldn't have lunch with my friends. I couldn't go to church. I love my son, but being trapped in the house all winter was terrible for my mental health." "And after the heated steps were installed," she smiled, "it changed everything. I could come and go freely. The steps are always dry and safe. I got my independence back." Derek showed her the cease and desist letter. "When you learned that the HOA wanted to remove your heated steps, how did you feel?" "Devastated. Terrified. I thought I'd be trapped again. I felt like such a burden on Xavier causing all this trouble." "Mrs. Thornton, are these heated steps a luxury or a necessity for you?" "A necessity. Absolutely. Without them, I can't safely access my home." Robert Mills tried to shake her testimony on cross-examination, but it was like attacking a grandmother in front of her grandchildren. The jury clearly sympathized with her. "Mrs. Thornton, your son could shovel the steps each time it snows, correct?" "He does, but ice forms between snowfalls. Black ice especially. You can't shovel something you can't see. Salt could be applied. Salt doesn't work when it's really cold. And it damages the concrete. My husband installed those original steps 30 years ago. I don't want salt ruining them." Mills tried a few more questions but gave up quickly. My mother's testimony was bulletproof. Next, Derek called Dr. Chen, who testified about my mother's medical needs and the necessity of ice-free accessibility. She was professional and authoritative, explaining in clear terms why heated steps weren't a luxury but a medical necessity. "In my professional opinion," Dr. Chen concluded, "heated steps are the most effective permanent solution for ensuring Mrs. Thornton's safe access during winter months. Manual ice removal is unreliable and depends on constant vigilance. Heated steps provide continuous protection. The HOA's attorney barely cross-examined her. What could he say? She was a licensed physician with detailed medical records supporting her opinion. Derek then called Mike, the contractor who'd installed the steps. Mike brought photographs and technical specifications, showing the jury exactly how the heating system worked and how unobtrusive it was. "You can't even tell these steps are heated unless you're told," Mike explained. "The pavers look identical to standard ones. The control box is tiny and mounted out of sight. From the street, you'd never know there was anything special about them. In your professional experience, are heated steps a common solution for accessibility needs?" "Very common, especially in Colorado. I install probably 50 systems a year, many for disabled or elderly residents. They're safe, energy efficient, and permanent." The defense called their expert, Richard Crane, who tried to argue that heated steps weren't necessary under ADA guidelines. Derek's cross-examination destroyed him. "Mr. Crane, you testified that manual ice removal is sufficient for ADA compliance, correct?" "Yes." "Are you familiar with the case United States versus City of Seattle?" Richard hesitated. "Not specifically." The Department of Justice sued Seattle for failing to keep sidewalks clear of ice and snow, arguing it violated disabled citizens' rights under the ADA. Seattle settled for over $1 million and committed to improving ice removal. Does that sound like the ADA is flexible about ice-free accessibility? I'm not familiar with that case. Let me ask a simpler question. You live in Denver, correct? Yes. Have you ever tried to keep a walkway completely ice-free through manual removal during a Colorado winter? I shovel my own driveway. And is it always completely free of ice? Richard shifted uncomfortably. Not always, no. Because despite your best efforts, ice forms between shovelings, especially during freeze-thaw cycles. Yes. So manual removal is inherently imperfect, while heated steps provide continuous protection. In theory, yes. Not in theory, Mr. Crane. In physics, heated surfaces above 32 degrees Fahrenheit cannot support ice formation. That's a scientific fact, isn't it? Yes. No further questions. Patricia took the stand on the third day of trial. Robert Mills walked her through the HOA's bylaws and her responsibilities as president. She tried to present herself as a reasonable community leader, just enforcing rules fairly. Then Derek stood for cross-examination, and everything changed. "Miss Winters, you received a letter from my office on November 15th outlining the ADA requirements for ice-free accessibility, correct?" "Yes." That letter included citations to federal law and court cases where HOAs had lost similar disputes. "Yes." "And you ignored it," Patricia stiffened. "I didn't ignore it. I consulted with the board and we decided to proceed with enforcing our bylaws." Derek displayed the email chain between Patricia and the other board members. "This is an email from Melissa Cook suggesting you consult with an ADA attorney before proceeding. Your response was, and I quote, 'The ADA doesn't override our covenants.' Is that correct?" "Yes, but you meant exactly what you wrote, Miss Winters. You believed HOA covenants were more important than federal disability law. That's not fair. I was trying to maintain community standards. By violating federal law, I didn't think we were violating anything." Derek's voice sharpened. "You didn't think, or you didn't care, because the evidence shows you were repeatedly warned and chose to proceed anyway." Robert Mills objected, but Judge Martinez allowed the question. Patricia's face was red, her composure cracking. "I cared about treating all residents equally," she said. "By denying a disabled woman the medical accommodation her doctor said she needed. There were other options for ice removal. manual shoveling that depends on someone being available constantly, salt that doesn't work in extreme cold. Those are your preferred solutions for a wheelchair user. I don't know. I'm not a doctor or an engineer. I just know that rules exist for a reason. And federal disability law exists for a reason too, doesn't it? Patricia didn't answer. Derek let the silence stretch, then continued. Miss Winters, let's talk about your actual motivations. You've been HOA president for 6 years, correct? Yes. In that time, how many residents have you fined for various violations? I don't have an exact number. Derek held up a spreadsheet. According to HOA financial records, you've assessed over 300 fines totaling more than $80,000. Does that sound accurate? Patricia's attorney objected, arguing relevance. Judge Martinez sustained it, but the jury had heard the number. Derek moved on. Miss Winters, the real reason you demanded removal of Xavier's heated steps wasn't about process or rules, was it? It was about control. You couldn't stand that someone had made a change without your permission. That's not true, really. Let me read you this email you sent to the board after receiving my second letter. If we back down on this, it will signal weakness and everyone will start ignoring our authority. Your words, correct. Patricia looked trapped. I was concerned about setting precedent. About your authority being questioned, about losing control, and you were willing to violate federal law to maintain that control. I never intended to violate any law, but you did, Miss Winters. You did violate federal law. And when you were told about it repeatedly, you didn't care enough to stop. Derek returned to our table, leaving Patricia visibly shaken on the stand. Robert Mills tried to rehabilitate her testimony on redirect, but the damage was done. The jury had seen her true motivations clearly. The trial lasted 5 days total. Derek called character witnesses who described Patricia's authoritarian approach to the HOA and her pattern of excessive enforcement. The defense called a few residents who supported Patricia, but their testimony felt hollow compared to the powerful disability rights narrative Derek had built. Closing arguments came on Friday afternoon. Derek's was masterful, weaving together all the evidence into a compelling story about a disabled woman's right to access her home and an HOA president who put her own authority above federal law. Ladies and gentlemen, Xavier Thornton just wants to leave her house safely. That's it. That's all this case is really about. Federal law protects her right to make necessary modifications to achieve that basic goal. Patricia Winters tried to take that right away, not because of any legitimate concern, but because Xavier didn't ask permission first, because her authority was challenged, because she valued community standards over a disabled woman's safety and dignity. Derek pointed at Patricia. She was warned. She was educated. She was given every opportunity to back down gracefully, and she chose to proceed anyway. That's not just negligence. That's willful discrimination. The law is clear. The facts are clear. And I trust you'll return a verdict that makes it clear to HOAs everywhere that disability rights aren't optional. Robert Mills tried his best in closing, arguing about property rights and the importance of uniform rule enforcement. But standing next to the image of my mother in her wheelchair, his arguments sounded petty and legalistic. The jury deliberated for 3 hours. When they returned, the forewoman was the woman with the cane. She looked directly at my mother when the verdict was read. In the matter of Thornton versus Sunset Ridge Estates, HOA, on the claim of disability discrimination under the Americans with Disabilities Act, we find in favor of the plaintiff. On the claim of Fair Housing Act violations, we find in favor of the plaintiff. On the claim of emotional distress, we find in favor of the plaintiff. I grabbed my mother's hand as the verdicts continued. The jury awarded us $30,000 in compensatory damages, $20,000 in punitive damages, and full attorney fees. They also granted the injunctive relief we'd sought, permanently prohibiting the HOA from interfering with the heated steps. Patricia's face went white. She stood abruptly and walked out of the courtroom, leaving her attorney to handle the aftermath. Several HOA board members who'd attended the trial looked relieved, as if a weight had been lifted. Judge Martinez thanked the jury and scheduled a follow-up hearing to work out the specific terms of the injunction. As the courtroom emptied, my mother was crying, and for once they were happy tears. "Thank you," she whispered to Derek. "Thank you for fighting for me." "Thank you for being willing to share your story," he replied. "This verdict is going to help a lot of people beyond just your heated steps." He was right. News of the verdict spread quickly through legal circles and disability rights organizations. Derek started getting calls from other residents facing similar HOA disputes over disability accommodations. The case set a clear precedent in Colorado federal court that HOAs couldn't override ADR requirements, no matter what their bylaws said. 2 weeks after the verdict, I received a letter from the Sunset Ridge Estates, HOA. Patricia had resigned as president effective immediately. Melissa Cook had been elected to replace her, and the board had voted unanimously to update the HOA bylaws. The new language explicitly stated that disability accommodations required by federal law were automatically approved and exempt from architectural review processes. "We apologize for the distress this matter caused to you and your mother," Melissa wrote. "The board is committed to ensuring all residents feel welcome and supported in our community. We hope you'll consider this a new chapter for Sunset Ridge Estates." I showed the letter to my mother, who smiled. "Do you think Patricia learned anything?" "Probably not," I admitted. "But at least she can't hurt anyone else in this neighborhood, and maybe the next HOA president who thinks about ignoring disability rights will remember what happened here." The HOA paid the judgment within 30 days. Derek took his attorney fees and donated half to a disability rights nonprofit. With the remaining settlement money, my mother and I took a vacation to San Diego, where she enjoyed accessible beaches and perfect weather. It was the first real trip she'd taken since her stroke. When we returned to Boulder in June, I found a surprising letter in my mailbox. It was from Tom Patterson, the neighbor who'd been fined for his fence height. "Xavier, thank you for standing up to Patricia and the board. Your lawsuit gave several of us the courage to push back too. The new board has been reviewing old fine disputes and reversing many of Patricia's decisions. They refunded my $2,000 last week. You didn't just help your mother, you helped the whole neighborhood. Beers on me next time I see you." Similar notes arrived from other residents over the following weeks. Jennifer Mills got approval for her solar panels. A couple who'd been denied permission to plant native wildflowers received retroactive approval. The neighborhood was slowly becoming less about rigid control and more about actual community. Patricia moved out of Sunset Ridge Estates that summer. I heard through the neighborhood grapevine that she'd bought a condo in Longmont, where, ironically, there was no HOA. Part of me felt sorry for her. She'd spent 6 years building a reputation as a powerful community leader, only to destroy it by refusing to accept that some things were more important than her authority. But mostly, I just felt relief. My mother could come and go freely, using her heated steps without fear. Winter arrived again and the system worked perfectly. Snow fell, ice tried to form, but the steps remained dry and safe. My mother attended her physical therapy, had lunch with friends, and lived her life without being trapped by weather. One cold December morning, I was having coffee on the porch when Melissa Cook walked over. She'd proven to be an excellent HOA president, focused on genuine community building rather than rigid rule enforcement. "Xavier, I wanted to thank you again for what you did," she said. The lawsuit was a wake-up call for all of us on the board. We'd let Patricia get away with too much for too long. You forced us to remember that HOAs should serve residents, not control them. I'm just glad it worked out. It did more than work out. We've had 3 other residents request disability accommodation since the verdict, and we've approved all of them immediately. One guy needs a wheelchair ramp. A woman is installing grab bars. Everyone's getting what they need without hassle. That's how it should have been all along. She handed me a small wrapped package. "This is from the board, just a small token of appreciation." Inside was a plaque reading, "To Xavier Thornton, for standing up for what's right and making Sunset Ridge Estates a better community for everyone. With gratitude, the HOA board." I laughed. "An award from the HOA I sued. Different board, different attitude," Melissa said, smiling. "Patricia's gone and good riddance. We're trying to be the HOA that people appreciate instead of dread." That evening, I showed the plaque to my mother. She touched it gently, running her fingers over the engraved words. "You know what I'm most proud of," she said. "Not that we won, though that's wonderful. I'm proud that you didn't give up when it would have been easier. You could have removed the steps and found another solution. But you stood up for the principle that disabled people deserve full access to their homes. That takes courage. I learned stubbornness from you, remember?" she laughed. "And I'm grateful you did. These heated steps aren't just about me, Xavier. They're about every disabled person who faces barriers created by people who don't understand or don't care. You helped change that, at least in our little corner of Colorado." The following spring, Derek called with interesting news. "Xavier, remember how I said your case would help other people? Well, the Colorado legislature just introduced a bill that would explicitly require HOAs to accommodate disability modifications without architectural review. They're calling it a Leaner's Law after your mother. It's directly based on our case." "Are you serious?" "Completely. The bill has bipartisan support and is expected to pass. Your mother's going to be famous in disability rights circles." The bill did pass, signed into law by the governor in May. Leaner's Law required all Colorado HOAs to maintain clear bylaws stating that disability accommodations couldn't be denied or subjected to standard review processes. It included specific language about ice-free accessibility and cited our case as precedent. My mother was invited to the bill signing ceremony in Denver. She wore her best dress and cried when the governor shook her hand and thanked her for her courage. Local news covered the story, and for a few weeks, my mother became something of a celebrity. Disability rights advocates called her a hero. She handled it with characteristic humility. "I'm not a hero," she told a reporter from the Denver Post. "I'm just an old woman who wanted to leave her house. Xavier's the hero for fighting when it would have been easier to give up." But I knew better. She was the hero, and so were all the disabled people who'd fought similar battles before us. We'd just been lucky enough to win ours publicly and create change that would help others. Years passed. My mother eventually passed away peacefully in her sleep at 82, 5 years after the trial. She'd lived those final years with dignity and independence, able to come and go from her home safely regardless of weather. The heated steps remained, a permanent monument to her fight and our victory. I still live in that house in Sunset Ridge Estates. The neighborhood has become genuinely pleasant under new leadership. Melissa Cook served as president for 4 years before handing off to another reasonable person. The HOA focuses on maintaining property values and building community rather than controlling every minor detail of residents' lives. Patricia, I heard, eventually moved to Arizona where the lack of ice made heated steps unnecessary. I hope she found peace and maybe learned something from the experience. People can change, though often they need dramatic failures first. The heated steps still work perfectly, keeping the entrance clear through Colorado's harsh winters. Sometimes neighbors bring visitors by to see them, explaining the story of how one man fought the HOA and won, how federal disability law trumped local bylaws, and how an authoritarian board president learned that some things matter more than rules. But for me, whenever I walk up those heated steps, I don't think about the legal battle or the victory. I think about my mother, rolling down that ramp in her wheelchair with a huge smile on her face, free to go wherever she wanted. I think about how something as simple as ice-free steps gave her back her independence and dignity. That's what the fight was really about. Not laws or bylaws or HOA authority. Just one woman's right to access her own home safely. Everything else was just noise. And I'm glad we had the courage to fight through that noise to protect what truly mattered. The Americans with Disabilities Act exists because disabled people deserve equal access to housing, public spaces, and opportunities. HOAs have broad powers, but those powers end where federal rights begin. That's not a controversial statement, though Patricia Winters certainly tried to make it one. It's simply the law and the right way to treat our neighbors. My mother used to say that the measure of a community isn't how it treats its most powerful members, but how it treats its most vulnerable. Sunset Ridge Estates failed that test under Patricia's leadership, but passed it after she was gone. That's the real victory, more lasting than any lawsuit or legal precedent. The heated steps remain, keeping the entrance safe and accessible. They're not just an accommodation anymore. They're a reminder that when people stand up for what's right, when they refuse to back down in the face of bullying and bureaucratic overreach, real change becomes possible. One person with courage and the law on their side can take on an entire system and win. And sometimes, that victory extends far beyond one house or one family, creating ripples that help countless others facing similar battles. That's the legacy of my mother's fight and my stubborn refusal to remove those heated steps. Aliner's law has helped dozens of disabled Colorado residents since its passage. The legal precedent has been cited in HOA cases across the country, but the best legacy is simpler. It's knowing that my mother spent her final years with independence and dignity, able to leave her house whenever she wanted, safe in the knowledge that her home was truly accessible. Those heated steps, opposed so vigorously by Patricia Winters and the old HOA board, gave her freedom. And freedom, especially for disabled people too often denied it, is worth fighting for. So if you're reading this and facing a similar battle with your HOA, remember, federal disability law isn't optional. The Americans with Disabilities Act and Fair Housing Act protect your rights. HOAs have power but not unlimited power. And if you stand firm, document everything and get good legal advice, you can win, just like we did, one heated step at a time.